A very good morning and welcome to Learn Life. I'm Shashank Vizra with renowned senior advocate of Supreme Court of India, Subodh Markandeji. In this video, we will be discussing on the bribe for vote by the legislator part 2. So in episode number 67, we have seen how the Supreme Court, while interpreting Article 105 Clause 2 by majority of 3:2, give absolute immunity to the members of any parliament for anything said or any vote given in parliament. Please tell us how, in spite authority pronouncement of the constitutional bench, is against the seized of the same point again.
The present case before the Supreme Court is called Sita Soren versus Central Bureau of Intelligence.
Yes, sir.
It arises in appeal by specially from the judgment of the High Court of Jharkhand dated 17th February 2014 in writ petition criminal number 128 of 2013. It's also called MLA bribery case. Here, Sita Soren, a member of the Legislative Assembly of Jharkhand, was an elector. That is, he was a voter in the biennial election to the Rajya Sabha notified on 12/3/2012. She allegedly took bribe of rupees 50 lakhs for filing the nomination of one R.K. Agarwal and 2 crores for casting her vote in his favor in the poll that was held on 30th of March 2012. Now, in the meanwhile, what had happened due to interception of certain vehicles by the Income Tax Department on the directions of the Election Commission of India, a huge sum of rupees 2.15 crores in cash was recovered. And on the recommendation of the Election Commission of India, the President of India rescinded the notification dated 12th March 2012 in regard to the biennial elections to Rajya Sabha insofar as related to the state of Jharkhand. The Speaker of the Assembly gave sanction for the prosecution of Sita Soren under Section 19 of the Prevention of Corruption Act and Section 197 of the Code of Criminal Procedure. Uh, so the CBI prosecuted her under sections 120B and 171E of the Indian Penal Code and section 13 subsection 2 read with section 1D of the Prevention of Corruption Act 1988. The CBI filed charge sheet before the special CBI judge who took cognizance of the offence under section 120B of the Indian Penal Code and section 13(2) read with section 13(1)D of the Prevention of Corruption Act 1988.
Yes, sir.
She challenged the proceedings uh, in writ petition criminal number 128 of 2013. So the matter came up before a single judge of the Jharkhand High Court. So the learned single judge, relying on the Constitution Bench judgment of P.V. Narasimha Rao's case and noticing that the provisions of Section 1052, which deals with the Parliament, and 194(2), which deals with the state legislatures, are perimaterial, that is, they are identical. So the learned single judge dismissed the writ petition. Then Sita Soren filed SLP, a specialty petition, under Article 136 of the Constitution, and that gave rise to criminal appeal number 451 of 2019. Now, it came up for hearing before a three-judge bench presided over by the then Chief Justice, and having regard to the complicated nature of the case and other considerations, the Constitution bench referred it, uh, that is a three-judge bench, referred it for consideration of a Constitution bench. Then this criminal appeal number 451, arising from the special leave which was granted, of 2019, came up for hearing before a Constitution bench of, presided over by Justice uh, S. Nazir on 15th November 2022. Now it's a very piquant situation that Union of India as well as the appellant both argued before the court that earlier decision in P.V. Narasimha Rao's case is correct law and matter should be sent back to a three-judge bench and decided.
Yes, sir.
But the bench presided over by Justice S. Nazir, it held that no, they disagreed with the contentions raised by the Solicitor General of India and Mr. Raju Ramchandran, for the senior advocate for the uh, appellant Sita Soren, and said no, we'll hear this matter because it requires consideration. So the Constitution bench has appointed Mr. P.S. Patwalia, senior advocate, as amicus curiae, because the other point of view also has to be considered, no? So
Yes, sir.
court requires assistance. So amicus curiae has been appointed uh, to assist the court and
Mhm.
directed that the matter be listed on 6th of December 2012. So we'll very keenly follow further developments. As noted in our episode number 67, judgment in Narasimha Rao's case does require reconsideration. The majority view gives unrestricted immunity to the MPs and MLAs. And to my mind, most objectionable aspect is that immunity is not restricted to the official functions of the legislators, but encompasses their private and offending function of bribe taking. This is what I find very offending. Such a view is also not in consonance with the. We have seen in episode number 67 that on two aspects of the matter, it is not in consonance with the, because there there are cases which hold that only bona fide acts, that is something related to what you said in the house and the manner in which you voted,
Yes, sir.
bona fide. And that also must fall within the definition of your official function. Taking bribe is not an official function. It cannot be.
Yes, sir.
Bribe taking cannot be, your function as a member of parliament or member of legislative assembly. So, and then second aspect on which there are cases against Narasimha Rao's judgment, and that view is that only what is done in the chambers, that is within the precincts of the house, only that is Article 105 applies only to those acts which are done in the precincts of the house, not outside. Since the bribe has been taken admittedly in both the cases outside the house,
Yes, sir.
outside the precincts of the house, so there is no question of immunity in regard to those acts. So more than that, what I find is that all this, is contrary to our civilizational values and constitutional values. After all, we should strengthen the values and the basic structure of the constitution. Bribe giving is a despicable act. It should not be tolerated in the manner in which it is suggested that uh, they have absolute immunity. So I think the Constitution Bench has correctly, it's proceeding correctly in this matter, and we will keenly await the outcome of the arguments before the Constitution Bench.
Yes, sir. Yes, sir, that's all, and we will be concluding with the two videos, and we will be eagerly waiting for the further development if there is any bribe or not.